want to talk just briefly about the Jeffrey Epstein case. There was somewhat of a development here. We have talked about this story with you numerous times. So this is what we know today, Neama. A federal judge who presided over the sex trafficking case against Epstein, joining two other judges in rejecting the government's request to unseal grand jury transcripts related to the decades-long sexual abuse suffered by girls and young women who fell into his orbit. So this ruling today by Judge Richard Berman in Manhattan, it came after the judge presiding over the case against Ghislaine Maxwell also turned down the government's request here. So barring any reversal on appeal, the judge's decision forecloses the possibility of grand jury testimony being released now that three judges have reached the same conclusion. A federal judge in Florida declined to release grand jury documents from an investigation there in 2005 and 2007. Now, Neama, the Associated Press characterizes these rulings as a collective repudiation of the DOJ's effort to divert attention away from its stated refusal to release a massive trove of records in its possession and make clear that the still sealed court documents contain none of the answers likely to satisfy the immense public interest. So, Neama, I think the headline here is three federal judges, two jurisdictions and another jurisdiction, have denied the DOJ's request to release grand jury testimony and transcripts here. Are you surprised by this? Or, because you and I have discussed that it's extremely rare, it's extremely unorthodox for a federal judge to grant a request like this, even if it is coming by the Department of Justice of all entities here. Were you surprised by it or no?
Andrew, I'm not surprised. And each of the judges in Florida and New York, they got it right. Under the rules of criminal procedure, and we're talking about Rule 6, grand jury transcripts are secret. They're sealed. They're not to be unsealed just because there's a lot of public interest in the case. There's very few legal reasons why they can be unsealed. And even the judge said it in this case, really unsealing the transcripts in the most recent case really wouldn't add a whole lot. It's just a fraction of the evidence in this case. It's mostly law enforcement witnesses. So for folks that don't know, grand juries really serve two functions. One is to investigate, and an investigative grand jury may have subpoenaed documents that would be in DOJ files already. And they hear testimony. Oftentimes, because the rules of evidence don't apply, if you're a prosecutor, you don't necessarily put victims before the grand jury. You have your law enforcement witnesses summarize some of that testimony. That protects the witness and doesn't create impeachment evidence that could potentially be used against them at trial. So when you have these summary witnesses before the grand jury, they're not necessarily going to add a lot. For people that want the Epstein files, it's really those FBI memoranda, those 302s, those 402s. That's in Pam Bondi and Kash Patel's possession. They could release all that. So what they're talking about is a small fraction. There's no legal basis to unseal it. And it probably wouldn't add a whole lot to what we already know and wasn't made public in both the civil and criminal cases.
Yeah, Neama, just lastly, part of the judge's reasoning in this, he said a significant and compelling reason to reject the government's request was that the information contained in the very transcripts, quote, pales in comparison to the Epstein investigative information and materials in the hands of the DOJ. He wrote that the government's 100,000 pages of Epstein files and materials dwarf the 70-odd pages of Epstein grand jury materials here. So he's almost daring the DOJ to release what they have, saying the grand jury transcripts, the testimony there, that's nothing compared to what you guys have on Epstein. Just release it. I mean, we are told, we did report earlier this week, a lot of that is coming possibly on Friday before the House Oversight and Government Reform Committee. The DOJ in some capacity has agreed to release some of that here. I was struck by the judge's candor there.
I was too. And the reason the judge knows there's so much information is that this was the subject of a discovery dispute. So Maxwell's lawyers, some of the civil plaintiffs, they wanted discovery. The government wasn't producing it. There were letters back and forth. The judge had to rule on all this, and the production was made. So the judge knows what the DOJ has because the judge had to resolve this dispute. There was delays in disclosure. Not everything was disclosed in a timely manner. We're talking about terabytes and terabytes of data that the Department of Justice has. And if you review the correspondence and the filings in those previous cases, this is all well known. So when you have Department of Justice officials that say they're going to make the Epstein files public, and let's be clear, Pam Bondi can do it with a stroke of her pen. Now, she should redact information related to the sex abuse victims to protect their identity, but she can do it. The Department of Justice maintains the privilege, the law enforcement privilege, the deliberative process privilege, but they can waive that privilege. So folks like me, members of the public, members of the media, they can't compel them. But that is something the Department of Justice can unilaterally do. Maybe they will with respect to this congressional subpoena. If so, I would be pleasantly surprised.
All right, Neama Rahmani, as always, going from Menendez there to Epstein. Wow. We'll definitely, I think, be talking probably tomorrow and Friday about Menendez for sure. Neama, thanks so much.
Of course, Andrew. See you tomorrow. Talk soon.